Is the case against Donna Adelson about to be dismissed? Donna Adelson wants that. She's asked the court to dismiss the case against her, saying the state waited too long to prosecute her. She says the state waited so long that she now can't get the evidence that she needs in order to defend herself. Does this mean that Donna Adelson is going to walk free? We're going to talk about that tonight. I'll tell you why she says the court should dismiss the case against her. And then I'm going to give you my view on how likely it is that the court is actually going to do that. But that's not the only issue, because even if the court does not dismiss the case against her, even if she is facing a murder trial, she says she ought to get a consolation prize, a big, fat, juicy prize that would keep the state from using some of the most important evidence against her. A ruling keeping out that evidence could make a big difference at trial. So, how likely is the court to rule on that particular piece of what Donna Adelson is asking for? Be sure to hit the like button and subscribe to come back for more. Donna Adelson is accused of murdering Dan Markel along with her son, Charlie Adelson, and the state suspects her daughter, Wendi Adelson. Wendi had gotten divorced from Dan Markel. Wendi and Dan were going through a very bitter custody dispute, even though they were divorced. Donna wanted to see her kids, according to the state's theory, her grandkids. And so she wanted Wendi to move down to Miami where she lived. But Wendi lived in Tallahassee, where Dan Markel, her ex-husband, lived. Dan, the father of the children, was a professor at a law school there in Tallahassee, Florida. Donna Adelson is accused of murdering her ex-son-in-law. According to the state, Donna and her son, Charlie, hired two hitmen. Charlie went through his ex-girlfriend, Katie Medbanawa, and Katie then hired her boyfriend slash husband, Sigfredo Garcia, who also hired a friend of his, Luis Rivera. Money traveled from Charlie and probably Donna, according to the state's theory, down to Katie, and then was passed out to the two hitmen, Luis Rivera and Sigfredo Garcia. All of those people were involved in the conspiracy, according to the state. 4 of the 5 are already in prison. Donna Adelson is not. She is now being tried. The state also suspects potentially Wendi Adelson, Donna's daughter, and Charlie's sister may have been involved too. She's the one who had gotten divorced from Dan Markel. She was the one having the dispute over child custody with Dan Markel. But thus far, she hasn't been charged in any way. Donna Adelson says this shooting of Dan Markel took place a long time ago. And because you waited until 2023 to file charges against me, that's too long. Now I can't defend myself. I can't find the evidence that I need in order to defend myself. There's not a statute of limitations in a murder case, which means the state doesn't have a rule that it can only prosecute these cases for so many years. And if it doesn't prosecute them within that period of time, it has to just give up. That's not something that is true of a murder case. There's not a statute of limitations that sets a firm rule on what the state can do. But the law does recognize that a delay could prejudice the defendant. You don't, on the one hand, want murderers to get off scot-free. That's why there's not a statute of limitations. But on the other hand, as a matter of fairness, the defendant needs to be able to access evidence that would show he's not guilty of what he's accused of. So the law recognizes there could be a delay that would prejudice the defendant. And so in Florida, if delay prejudices the defendant and is in bad faith, then the court can dismiss it. That's the argument that the defense is making in Donna Adelson's case. So bad faith sounds like a very high standard, and it is. But the two sides disagree about just how high a standard that is. The defense says it would be bad faith if the prosecution chose to delay the case for a strategic reason. In other words, to make a difference in the case, to be more likely to win it. That is, according to the defense, exactly what the state did.
We don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip. And they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time they didn't flip. And so they waited, and because of that, we're put in a position where these records no longer exist.
The defense says the state has the exact same evidence against Donna Adelson now that it had back in 2016. Yet it waited 8 years to charge her. And that was part of the state's strategy, the defense says, because they were hoping somebody in the chain of people who have been convicted or have pled guilty, that one of them would turn on Donna Adelson. When nobody flipped, the defense says, well, they finally just went ahead and charged her 8 years later. The defense says it was prejudiced in two different ways. The first is that, at least in Charlie Adelson's trial, Donna's son, the state argued that there was a pattern of calls, that whenever there was something related to the conspiracy, Donna would call Charlie. Charlie would call Katie Medbanwa, his ex-girlfriend, and then Katie would call Sigfredo Garcia. It never went Donna to Katie or Katie to Donna. That never happened. It never went Sigfredo to Charlie. It was always in that particular pattern. But Donna Adelson wants to be able to argue that that's not an important pattern. That's what happened every day. I talk to my son Charlie every day. That doesn't mean anything. It's normal. And Charlie often talked to Katie. Katie, of course, called her boyfriend husband repeatedly. Donna wants to say this isn't anything weird or unusual, but the state only got phone records from May 2014 through July 2014. And Donna says those records are no longer available. The records outside that, we can't get them. That means we can't show that this is how calls went all the time, that this was nothing unusual. The defense says the court ought to dismiss the case, and if the court won't do that, it at least ought to prevent the state from making the argument that these calls established a normal pattern of the way the group called each other.
Now, Judge, we do argue in the alternative in this motion. And what we argue is if the court is not willing to dismiss the case, they should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all the call records, but they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists, and we don't have the ability to show it. With regards to the text message,
the second way that the defense says it was prejudiced is by the lack of SunPass records. SunPass is a card that would go on your car and would be attached to your credit card, and you would use that if you went through a toll booth while driving around in Florida. Now, the night of the murder of Dan Markel, Donna Adelson and Harvey, her husband, went up to Tallahassee to be with Wendi, as she and her sons were dealing with the fact that her ex-husband had been killed. The night of the murder, Donna drove past Charlie's home on her way up to be with Wendi. She sent a text to Charlie saying, "Outside your house." Those three words have become incredibly important. The state believes outside your house meant that Donna and her husband, Harvey, had driven directly to Charlie's house because they were bringing cash, which he could then hand to Katie Medbanwa, who could then use it to pay the two hitmen who had just killed Dan Markel. Donna says, by outside your house, I just meant I was driving by on the interstate past his house near where he lived, saying outside your house. I didn't mean I was stopping by the house. When Katie Medbanwa got on the stand and in a proffer she made, she talked about this night, and she mentioned that the money she picked up from Charlie was damp. She said that Charlie said it was because his mother had washed the money, literally laundered the money. So the state says Donna dropped by the house with this wet money And they know it was money that came from Donna because it was wet. And Charlie said she laundered it. And then that went straight through to the hitmen. It was what paid, at least in part, for the hit and the kill on Dan Markel. At Charlie's trial, the defense argued Donna was just driving by. She had nothing to do with that money, and the money wasn't for a hit. Charlie argued that he was being extorted by members of the Latin Kings gang who killed Dan Markel and then threatened to frame him for the murder unless he pays them. And he says, yeah, he paid up because he was scared. The defense says we could use those SunPass records, which don't exist anymore, to show that Donna Adelson never got back on the expressway outside his house. That means she didn't get off the expressway because there would be a record of her, maybe not of her getting off. That isn't what SunPass records, but there would be one of her getting back on after having stopped at Charlie's house. They say she didn't stop there and we could prove it if only we had those SunPass records. The defense says this is creating a hardship for Donna Adelson as she tries to defend herself against some murder charges.
It's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves.
The state says it did not intentionally wait to indict Donna. It said it just didn't zero in on how important that 3-word text message was outside your house, that they didn't realize how important that would be until they got a proffer from Katie Madbanoa about what she was going to testify about at Charlie's trial. She was already in prison herself, convicted in the murder of Dan Markel, and then she testified at Charlie's trial, and she made a proffer or an explanation of what she was going to say, a statement about what would be said at trial to the state.
The reason we didn't try to get the SunPass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine Madbanoa offered that information in 2023, leading up to Charlie's trial and at Charlie Adelson's trial. Catherine Madbanoa mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before you continue,
Yes, sir.
was this new information learned either through the proffer or trial preparation that had never been or never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which was all in 2023. The trial being Charlie Adelson's trial in fall of 2023. Obviously, Donna Adelson's phone locations, right, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from, and that was this relevant to the money drop, until Catherine Madbanoa said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was damp. She believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived, and that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, and we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside her house. But this wasn't a situation where we waited to indict Donna Adelson until SunPass records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had to have been a deliberate act to gain a tactical advantage, and that's not what we have here.
The defense is not buying that excuse. They think the prosecution knew perfectly well that text messages from Donna to Charlie were important, and especially on the night of the murder.
And you don't have many text messages between the two. And you have one, and by the way, you only have like 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up outside your house, 10 minutes is the response, was not an important text message.
The defense also thinks that the prosecution knew enough to get some records in advance, and they could easily have known to get SunPass records while they were getting financial records, but they didn't.
They got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back.
My guess is it would be very unlikely that the court would entirely dismiss the murder charges against Donna Adelson. Particularly with the call patterns, it's not very likely that the court would rule that the case would be dismissed. After all, there are several months of data, and Donna can clearly argue that there was nothing abnormal about her calling her son, and the jury would believe that. It's the quick succession of the calls that the state is really pointing to, how quickly the calls went from one to the other. It's not that it was unusual for Donna to call Charlie. As for the other question about the SunPasses, that's a little more important. And the judge said he was going to go back. He was going to look at the proffer from Katie McBanawa. He was going to evaluate, was the state right when the state said it didn't really zero in on this beforehand? We don't have a ruling yet, but we'll be getting one soon. I'd be very surprised if the judge completely dismissed the case against Donna Adelson. Now, another couple of issues to catch you up on quickly. You may remember that the defense had asked the court to move the trial to a different, smaller courtroom. The defense said when we had Charlie Adelson's trial, there were some unruly spectators. There were some outbursts in the courtroom. There was even one incident where people in the court took a photo of a note that Charlie was passing to his attorney. Obviously, that's not cool. And they argued that the way to deal with all of that is to move the case to a smaller courtroom and have fewer members of the public able to see the case at all. They wanted to keep the public to an absolute minimum. The defense also said that that courtroom would give them a better view of the jurors, that in the courtroom where they typically have the case, they don't have as good a view of some of the jurors. The state made a really practical argument about why it wanted to stay in courtroom 3G.
The primary reason for us asking that it remain in 3G is just from a practicality standpoint in presenting the case. You know, in 3G, we have the big screen overhead. We have the multiple screens in the jury box for the individual jurors. We have a screen, an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector that from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes the state has to actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and I know the
You
court knows.
know I hate that television.
Right, it's a pain. And so, being in 3G isn't just something that we do for, or we've asked for. In this case, we asked for it in all cases where we have a lot of visual evidence to be shown.
The court was wholeheartedly on the side of the state, especially because technology is so much easier in courtroom 3G. The court said he would take measures to ensure that there weren't any distractions in the courtroom. He would rearrange the table for the defense counsel so they could see the jury better, and said, in general, I'm not going to let people distract the case. If I have to put people in handcuffs, I'll do that. But I'm not going to let the public be a distraction. And we do have a requirement that we have open courtrooms here in Florida. Another issue I want to draw your attention to, the defense asked for a jury questionnaire. That would be something that would be sent out to the jurors. Sometimes it's filled out when the jurors come in, or sometimes it's mailed to them. It's just a series of questions that they would answer, some related to the case, some about more general information. The defense wanted that, saying this is going to make jury voir dire, asking jurors questions, much easier. We've got to go through a bunch of people. We've got to narrow it down. This is a very high-profile case. It's going to be a task to get jurors who have not pre-decided the case, and this will help us be more efficient, make better use of our time when we do that. The state opposed that, saying, we want to see and hear every juror. We want to see their body language. The court ruled with the state, saying it's going to be sufficient to have voir dire for the jurors to be asked questions by the lawyers. We'll be able to figure out everything there. I'm not going to do a jury questionnaire as well. My personal view is that's a missed opportunity because I think juror questionnaires make things a lot easier. They are more efficient. In a case like this, with as many jurors as they will be bringing in and interviewing, I frankly think it would make a lot of sense to do that. So it's a missed opportunity, but I certainly don't think it's a mistake of a legal nature, something that would get a case reversed. I just think it would be easier for everybody if they went ahead and did that. Be sure to subscribe to the channel. We're covering this case in detail. If you'd hit the like on the video, I'd really appreciate it, and I'll see you in the next one.